So Ted Gill is a star, 5-star in your book, huh?
Yes, absolutely. The rated trades, he encouraged me to reach out to my past clients and have them actually write a review, and instead of just giving me the 5 stars, and the review actually made a huge difference in the Google ratings. Imagine, listen to the expert and then things get done. So I think all of us can relate to that. So fabulous.
All right. Well, tell us a little bit about you and your background and what you're going to talk to us about today.
Okay. We talked, Kurt, a couple weeks ago about some of my conflict resolution work. We were talking at one of the Team Networks meeting. I am a member of the TNT, Team Networks Tysons. What do we call them? Chapters? I don't know. Meetings? Teams? Yeah. Sure. Team Network teams. And we were talking, and you said, would I put on a little presentation about that? So I do have some slides and a little video to share. We're up for that.
You have the ability to share. Go ahead. Oh. Be great. Right. Let me remind everyone while she's doing that to please, if you haven't put your information in the chat box, I will do a follow-up email and encourage you all to follow up with one another. So the fortunes in the follow-up, as they say.
It is. And I myself have been learning a new CRM system. So talk about never stop learning and finding out new things about how to work on your business while you're working in your business. So I want to talk mainly about the options that you have when you have a dispute coming on. And this is different times and places. So a dispute can be anything from, like, I don't know, Saul always brings up a little thing, and I think he's the one that has kind of the boxing gloves or the boxing motif sometime when he logs in. So it could be anything from, you and your neighbor getting into some discussion over where the fence posts are going to go, all the way up to, a major issue. Also, Saul, to use you as an example, the condo collapse in Surfside, Florida. So, that's going to be a huge mess to work out. And I'm sure there's going to be a lot of mediation going on with that. So it could be anywhere from an informal to a formal situation. So what is it? What are the advantages and the disadvantages? And part of the definition is going to include what you feel the advantages are and what you feel the disadvantages are, because depending on yourself, your personality, and your actual situation, some of the things that are advantages may be disadvantages to you, and some of the things that are disadvantages may be advantages to you. So I'm not going to read you the whole whatnot, but I'm sure these slides will be archived somewhere. Thank you, Kurt, and all that. But basically, it's an alternative to going through the legal system or the court system, but it can also be part of the court system, and we'll get to that in a minute. So you may or may not have had a lot of communication beforehand when you go to a mediation. So part of the mediation process is creating that kind of safe space, people getting heard, people saying what their feelings are around something, what they really want to see the outcome of it. And it can actually be the parties talking directly to the mediator in a closed, direct conversation, or they can be all together now we're mainly on Zoom nationwide and worldwide. So in a Zoom room, whereas before we'd be in an open room, and then there would be additional actual rooms. So the parties would have, each party would have their own room, and then there would be a room that people would come in to together physically. Has anybody been in a mediation before? Let me pop up.
Yes.
Yes. Okay, great. So you kind of have the idea of the rooms and the way that things are exchanged. It's a little bit different than going into a courtroom and you're kind of just called up one by one, and it's very triangular. You're presenting something from the judge or answering only one question at a time. This can be very much more organic and fluid. And it kind of depends on if you like that or not, or if you want that for your case. So that comes up to some of the advantages and disadvantages. And I see we have a couple more people joining us. Great, that's awesome. So basically the outcome in a mediation is party driven. And that is an advantage, but sometimes it's not really what people want. Sometimes people want to just hand it over to somebody and have a third party decide. So, but mediation can also save on court costs. It can also save a working relationship. You know, you go to court with somebody, sometimes that's it, that's the end, relationship over. But what if they're the only custom cabinet maker in 100 miles, and it would be completely cost ineffective to break any relationship you would ever possibly have with this party again. So you may want to actually look at that before you go into some sort of litigation situation where it's going to sever that relationship entirely. You can draft your own settlement. Some people may want to do that. Some people may not. Emotional. It can actually be emotional. You have time. Has anybody ever been to like small claims court? Yeah. Okay. So you have like what, 30 seconds to tell the judge like everything you want to tell them. I mean, maybe a minute, 2 minutes, whatever. And then he or she is on to the next thing. Right. So not a lot of time to like really get out. Hey, I was wronged and this was why I was wronged. It's only like really, you have a legal argument and that's it. So the emotional argument and the hurt and all that really just doesn't come into play. And talking to the judge confidentially, is that going to happen? No, probably not. In fact, you're going to have to go up there and the other party is going to have to go up there if they even let you, especially like.
I was going to interject only if you do ex parte and then you're in trouble, which
Yes. Good. Who is this? Is that, do I have a lawyer pop on?
Oh, Dr. Andrea Adams Miller. No, I just used to work in law enforcement and was a CASA advocate, and we own rental properties. So yeah.
Okay. Yes, absolutely. So yeah, with rental property too, same here. So definitely different. You definitely know the small claims system, and it's kind of just you feed through. You have just a second to tell your story, and yes, no, granted, denied. No discussion about it. So definitely there's more of a way to talk to somebody to work it out. Of course, the mediator is not making any decisions, but they are allowing you to be heard, which can go a long way. And the settlement can be binding. People always go, well, mediation isn't binding, and it depends. So if you agree for it to be binding, you make a contract, an agreement, or a memorandum of understanding, depending upon how you want to do it and what jurisdiction you're in. And then if somebody breaches that contract and goes ahead and sues you on whatever matter you settled in mediation, then you just go to the judge and you say, hey, look, this is settled. Granted, you're in court telling the judge something, and you really didn't want to ever have to do that, but that's where you're at. So not as much of a done deal as a judgment, because, if you had a judgment, they would look at it and just say, oh, there's a judgment, too bad. But, pretty close. So that gets over to the disadvantages. So with the disadvantages, no formal rules of evidence. Again, some people could look at this as an advantage. No witnesses. So this all kind of plays into like why it doesn't take as long. So all those discovery delays, I mean, you can do discovery delays as you know, I practice in Louisiana and Michigan. So I've practiced law. So one of the tactics of defense attorneys primarily is to delay. And the best place you can delay is discovery, is gathering these rules and setting those benchmarks as far out as possible. So you can delay a civil trial for literally several years. And in a mediation, you're really not waiting on that. I mean, there may be some things that you really need to get, but if you don't need to wait on it, you don't need to wait on it. But again, that's pros and cons, because if you're not waiting on evidence, you may be leaving money on the table. So you don't know. So you don't know if your settlement is fair. So that's one of the disadvantages. You do have, or at least in most of the mediators that I know and work with, and myself, I do have a time, like you don't have to sign at the table. So you have time to go to your attorney with everything that you've discussed. You can get your attorney on the phone. Your attorney can come. You just don't need to pay him, he or she to be there the whole time, but they certainly can come and they certainly can be there the entire time. I'm just not sure why you'd be paying me and them, but they can go back and you can absolutely sleep on it. Don't like to take too much time, because then again, you're going into that benefit, that time cost benefit. So you can find out if your settlement is fair. Some mediators do like to go, especially if you're on the eve of court, you may have to decide right then and there whether you're going to sign or not, but that's different circumstance. Your parties you do a lot of your own work. So for some people who like to just hire out things done, like hire a lawyer and just call me and tell me how much it costs when it's done, maybe mediation's not for you, because this is something where you are going to have to do your own participation. So, and a suit may be filed later. So the agreement made at mediation would be entered as a defense.
How do you get paid?
That's an excellent question. One or both of the parties pay up front for mediation. And that's one of the reasons mediation and arbitration differs. Arbitration is usually split up front, which is a pretty hefty fee.
And if you have if Ryan was good with his agreements and contracts and leases, a lot of times in those things, instead of going to court, you got to first go through mediation. And supposedly it is binding mediation. Would that be true or false?
It's binding if you agree for it to be binding. I mean, basically what a mediator does is keeps you between do you ever gone bowling with kids and they put those bumpers up on the side of the bowling alley so that the ball doesn't go into the gutter?
I still use them for me.
Okay, perfect. So the ball doesn't go in the gutter. So I kind of liken my job as a mediator is to kind of keep the ball in play. And if we resolve points along that play, then those are the things we draw up in a memorandum of understanding, agreement, whatever type of agreement we choose to use at the end of the session. So those items will then become binding, just as any contract is binding.
So what you're saying is, and Ryan can probably jump in and correct me, but if I had a contract, an agreement to build something, and in that agreement, it says that if there's anything I had to go to binding resolution, my hands are tied because I have to use binding mediation resolution versus going to the courts, according to the contract I signed in advance.
Well, that wouldn't be correct. That would not be a correct usage of the terms. Binding and mediation don't go together. Binding and arbitration go together.
Right.
And binding and litigation go together. So Ryan, I'll be happy to toss this off.
You're good at it too. I know you've done a little bit of litigating yourself, but I would agree 100% with Daya. Of course, your ultimate remedy is to sue somebody for breach of contract. So if they fail to do so, if they fail to mediate, or if the mediation fails because the two sides can't agree, even if mediation is in there, then you get to sue. If the contract is written with binding arbitration in there, then there's an arbitration clause, and you go to one of several arbitrating organizations, usually the American Arbitration Association or something like that, and pay the fees for the arbitrators. And there's usually contract litigation about that. Sometimes that's more expensive than going to court, especially for something where the dispute is, less than $100,000, because court costs, what actually happens in some states, if it's below, say, 100,000 or 50,000 or 30,000 or whatever it is, it's going to a smaller court with less discovery, and it's going to be less expensive to actually litigate, even if you hire an attorney, than it is to go to arbitration. Arbitration is not always less expensive. It's actually kind of pricey sometimes.
It's pretty pricey. And actually, Sometimes people try to get out of their own arbitration clauses. Now, some industries are arbitration specific, and I wouldn't be surprised if maybe some insurance carriers had arbitration in their agreements. Financial has to go through FINRA. There's actually an arbitration body that's set up that they have to go to arbitration. And then some companies put it in their agreement, and actually Amazon just took it out of their contract because they had 75,000 arbitration claims made, and it would be cheaper. It's cheaper for them because see, they have to pay the costs. They have to pay half the cost on that out of the gate. And so they said, no, never mind. We're going to scratch our own arbitration clause out of our agreements and have it filed as a class action in litigation. So
Yeah.
that ended up cheaper for them.
Yeah, and actually in the insurance world, generally it's prohibited under state law in many states to have an arbitration clause with a consumer.
Got it.
Right. Okay. I mean, and you're right, because I wanted to make sure that arbitration and mediation aren't confused as being one.
Yes, that's a huge point, and a lot of people do. They come and they say, "Oh, well, you're going to tell us what to do if I hire you to mediate," and I'm like, "No, I'm not. It's not you. You will be deciding between your parties how you want to handle this." And that's why if you want a hands-off approach and you want someone to tell you what to do, mediation may not be the right avenue to take.
So Daya, mediation really only works if both parties want to engage then, right?
I think
Can you get where you want to if one side wants to mediate, the other side really doesn't want to do that?
I look at part of my job is assisting in someone seeing the value of it, even if they're reluctantly there. The court often sends you to mediation, especially in small claims, and it depends on the jurisdiction. So I'm actually a contract mediator in other jurisdictions that I don't actually practice law in. And the court will send people to mediation. And so it's kind of half and half. I really spend a lot of time letting them know that the process will be better if they come around and kind of take some enjoyment, take some ownership of it, take some, hey, you know what, you're really going to be able to decide this for yourself. However, if they're really stuck on they're 100% right and the judge is going to see that, I mean, maybe we can do a few things, maybe we can get a few things out of the way and they won't have to go to court on those issues. And so they'll spend less time in court and the judge will see that they have some goodwill because they have settled some of the things. But yeah, you can't force somebody to come to the table.
So what would be the 2 or 3 things that you would advise somebody that wants to be successful in mediation then, to get where they want to, to get to a good outcome?
Yes, I mean, it's really going to depend on it's really case by case, and it's going to depend on what they want. And the key things are that cost, the relationship, and the time aspect. I work a lot in construction arena, and the time is money exponentially. And then as well as the relationships, the supply and demand. If you have to work with these people or use these same suppliers again and again, I mean, you don't want to tie them up in court for 5 years, especially if they're going to not supply it to any of your jobs during that time. So you really have to balance it out on each one, each case by case. I try to get people to communicate more on the front end so they end up in this situation less often.
When you were also, I mean, for this meeting, we're talking about conflict resolution. Now, mediation, of course, is that. What would you think, or let's say I have an employee who refuses to get vaccinated, and how do I deal with that conflict?
I would take to your HR person. I don't want to, since this is being recorded and possibly simulcast over multiple jurisdictions, I can't open that can of worms in 12 minutes or probably 12 hours. But yeah, stay tuned on that one. Stay tuned. That's it depends, and a changing minute to minute, and very, very geographically venue orientated.
Oh, I like the way you danced around that.
Yeah, well, we talked, if we're following the slides a little bit, we already talked about this one. Saul, you brought that up about the agreements. And again, it depends. So even if there's an agreement or something already in the contract there, we can dance around that one too.
Isn't that always the case though with lawyers? Like the most accurate answer we can always give is it depends.
It really does. It really does. Yeah, and in any of the practice, any area that I don't practice in, I basically say I can answer your first two questions, and then I'm going to have to refer you. So, because I'm reaching back to like 20 plus years ago when I was in school, and you don't want that. You want somebody who knows, who's read the articles and kept up with your jurisdiction and that's why they don't let us practice in every state we want to practice in. I'm like, we got to keep up with the times. And that's another thing that's different between a mediator and an attorney, because I do work in multiple jurisdictions as a mediator. I don't have a geographic boundary because again, I'm working really on what the parties want as opposed to what the law is going to say.
Daya, I have a question.
Yes.
Going back to the ideas, vaccination imposed by the employer, how about fingerprinting? When you work any security like banking and stuff, they expect you to be fingerprinted.
Yes.
And so is that legal?
It goes to employment. I mean, the crux of the argument is the employment being employment is not a right, it's a privilege to work, and there's always going to be certain conditions of employment. Employment law is changing again quicker than the vaccine and the virus is mutating. It's employment law is extremely, there's federal employment law that covers everything, and then how it's implemented into the states. And the states are doing, as we can see on the news, very, very different things about how things are being applied and enforced. So it depends over here. But as far as security, especially in Northern Virginia, where most of us, our businesses are based, you're not going to see the fingerprinting going away. And I've been fingerprinted so many times I can't tell you, because every time I went for a license or a degree or even a tour guide.
Honestly, I'm not against it. I was just curious.
Yes, yeah. There are conditions of employment, and that's an issue. That's a contractual issue. And then some things are fair, some things are not fair. If you want to get into a whole nother slate of harassment and discrimination and things like that, there will be another couple of weeks we could talk about all that. Yeah, thank you for your question. I appreciate that. So here we are, some more deciding factors, like how do we want to decide, and how involved do I want to be? Again, some people just want to lawyer up, especially people who have general counsel in their office. They're like, hey, I'm paying those guys anyway, guys and gals anyway. I'm just going to have them handle this. Why do I care what the outcome is? Leftovers, you may have some stuff that's not. You may come to an 80% agreement or a 90%, 95% agreement in mediation. And then again, you have to go through the same decision factor about whether or not you're going to litigate that extra 5, 10, 15%. You have to look at your bottom line and whether you want to go after it. Let's set up a one-to-one. You should be able to scan this with your camera, not your QR reader, and goes to my calendar link. And yep, we're right here right on time. So set up some time to talk. I would love to get to know you both as a Team Networks member and also to continue this conversation. So I'll give everybody like 2 minutes to scan that if they want to scan it. And then I'll give the meeting, I'll go ahead and give the meeting back to Kurt so he can start wrapping us up.
All right. Why don't we give Daya a round of applause? Thank you very much. Very good, very good.